matter of Herculito Maritime Ltd and others against Gunvor International BV and others.
Lord Hamblin will explain the court's judgment.
The background to the appeal. On the 30th of October 2010, the marine tanker Polar, which I shall call the vessel, was seized by Somali pirates while she was transiting the designated high-risk area in the Gulf of Aden off the east coast of Africa during a voyage from St Petersburg to Singapore laden with a cargo of fuel oil. The vessel was held captive for 10 months before being released on 26th of August 2011 following the payment of a ransom of $7.7 million by or on behalf of the vessel owner, the ship owner. The ship owner claims that the owners of the cargo interests, are liable to pay a proportion of the ransom payment in general average. Such a liability arises where extraordinary expenses are incurred for the preservation of a ship and cargo and requires those losses to be borne proportionately by those interested. The cargo owner's proportion is said to be $5.914 million. The cargo interests contend that they have no liability in general average in respect of the ransom payment. They submit that, on the true construction of their contract with the ship owner under the bills of lading, the ship owner's only remedy was to recover the ransom payment under the terms of additional insurance cover which had been taken out in relation to such risks pursuant to the war risk clauses of the governing voyage charter party, which I shall refer to as the charter, the premium for which was payable by the charterer. The dispute was referred to arbitration, and in an award dated 8th of January 2020, the arbitrators upheld the cargo interest case. On appeal, Sir Nigel Tier allowed the shipowner's appeal. The Court of Appeal upheld Sir Nigel Tier's decision. The cargo interests now appealed to the Supreme Court. In its judgment, the Supreme Court unanimously dismisses the appeal. I give the judgment with which all the other justices agree. The reasons for the judgment. 4 issues arise for decision. The first is whether, on the proper interpretation of the Charter and or by implication, the shipowner was precluded from claiming against the Charterer in respect of losses arising out of risks for which additional insurance had been obtained pursuant to the war risk clauses. It is well established that contractual parties may agree that specified loss or damage is to be covered by insurance, and that in the event of such loss or damage occurring, the parties will seek recourse against insurers rather than their contractual counterparty. In the shipping context, such an insurance code or insurance fund has been held to exist under a demise charter and under a time charter. This is the first case in which it has been necessary to consider whether there is an insurance code or fund in a voyage charter, and if so, in bills of lading which incorporated the voyage charter terms. In support of their case, the cargo interests rely in particular on the 1983 House of Lords decision in the EWCA No. 2, in which an insurance code was held to have been agreed in a time charter. A critical question is whether the charter is materially different or distinguishable from the time charter in that case. For the detailed reasons given in the judgment, the terms of the charter are materially different to those of the charter in the EWCA No. 2, which decision can and should be distinguished. In particular, against the background of the specially agreed contractual regime for the known piracy risks of transiting the Gulf of Aden, it would not have been open to the shipowner to contend that such risks were war risks which entitled it to refuse to proceed there. In those circumstances, this is not a case in which the charterer would otherwise obtain no benefit from the payment of the additional premium, nor is it one in which it was undertaking a significant additional burden. Further, tribunals should be cautious before concluding that the reasoning and decision in the EWCA No. 2 should be followed in relation to differently termed charters. In particular, First, English commercial law recognises the importance of certainty and fosters it so far as possible. Secondly, the search for an insurance code introduces uncertainty. Thirdly, if parties wish to provide that there can be no right of recovery or subrogation in respect of loss or damage covered by insurance, that can be easily stated expressly. And fourthly, there are various practical difficulties which may arise, such as disclosure to insurers. There was therefore no insurance code or fund agreed in the Charter. The further issues which arise are addressed on the assumption that there was such a code and concern whether that code was incorporated into the bills of lading. The second issue, whether all material parts of the war risk clauses were incorporated into the bills of lading. The shipowner contends that those parts of the war risk clauses which concern the obligations of payment of insurance premia are not directly relevant to the loading, carriage, and discharge of the cargo or the payment of freight, and therefore are not incorporated into the bills of lading. In the judgment, the leading cases on the incorporation of charter terms into bills of lading are considered, and the relevant principles summarised. Applying those principles, the Court agrees with the judge in the Court of Appeal that this argument should be rejected, on the grounds that the clauses relate to the route to be taken by the vessel, and therefore are directly relevant to the carriage. The third issue, whether on the proper interpretation of the war risk clauses in the bill of lading, and or by implication, the shipowner was precluded from claiming for its losses against the bill of lading holders. Once clauses of the Charter are incorporated into bills of lading, they are treated as being fully set out in the bill of lading contract. The clauses must then be interpreted in the context of that contract, and for the purposes of Issue 3, it is assumed this involves no manipulation of the wording. The cargo interests argued that the Charter should be regarded as paying the additional insurance premia on behalf of cargo interests, as it is they, rather than the Charterer, who will be most directly concerned in the event of kidnap and ransom, and they who would bear the principal liability to contribute in general average. There is, however, no term with the Charter which supports this analysis. The obligation is that of the Charterer, and it has its own interests in ensuring proper performance of the Charter. Moreover, there is no insurance code or fund case which extends any understanding to that effect beyond the parties to the relevant contract. The fourth issue, if necessary, whether the wording of the war risk clauses should be manipulated so as to substitute the words the charterers with the holders of the bill of lading in the parts of those clauses allocating responsibility for the payment of the additional insurance premia. Manipulation of charter clauses incorporated by general words of incorporation may be permissible if it is necessary to do so to make the wording fit the bill of lading. There is no such need in this case because the allocation of responsibility for payment of additional premia makes sense in the context of the bills of lading as a record of the terms upon which the shipowner has agreed to transit the Gulf of Aden. There is therefore no justification for manipulation. Further, as held by both the judge and the Court of Appeal, there are positive reasons why there should be no manipulation, such as the implausibility of bill of lading holders accepting a potential liability to pay unknown and unpredictable amounts. In conclusion, the shipowner succeeds on issues 1, 3 and 4, and it follows that the appeal must be dismissed.